time. Now, we are on the point that here the general and special rules of evidence. We are dealing with the special rules. You may say that. What are the various special rules of evidence in the in the CrPC, along with the Evidence Act? So far, from the provisions of Section 272 onwards till 293, how we discovered that here the witnesses who are sought to be examined, they must come before the court. That is the mandate of Section 137 CR of the Evidence Act, which says that here the person who want to give evidence must come before the court and give evidence. His cross-examination is taken in the court, and uh, principally there is no, because the Evidence Act excludes the affidavits completely, but certain provisions of the Code of Civil Procedure as well as CrPC permit the filing of affidavit as evidence in the matter. Now we learned that here. Now in Section 295, we learned that here the conduct, the proof, the conduct of a public servant can be placed on record by way of evidence in affidavit. Section 295, which is a general exception to the rule, which is an exception to the general rule under the Evidence Act, that you cannot lead evidence by affidavit. When there is a special provision contained in any code of law, in any code, that special provision shall override the general provision. What the provisions in the Evidence Act contain, that here under Section 1 of the Evidence Act, affidavits are excluded generally. That's a general provision. But certain provisions in CPC and CrPC, like Order 18 Rule 4 ACPC, tells you lead affidavit. Affidavit will be an evidence. Under Order 9 of the Code of Civil Procedure, you read it here, the court may treat it as an affidavit. Then for the purpose of determining order of passing an order of injunction and interlocutory orders, the court will decide that the under Order 39 rule of the provision, all the affidavits are considered as evidence at the interlocutory. Now, Section 295, when you see, affidavit in proof of the conduct of a public servant. So, see, when in any application is made to any court in the course of inquiry, trial, or other proceeding under this code, an allegation is made therein respecting any public servant, the applicant may give evidence of the fact alleged in the application by affidavit, and the court may, if it think fit, order the affidavit relating to such facts so given. So you may prosecute a police officer for not having taken down the FIR on assaulting you, abusing you. You have filed a criminal case after following the procedure laid down under 197, or a learned magistrate or the judicial magistrate or any public servant has abused you, assaulted you. After following the procedure under 197 CrPC, you have launched prosecution. So you are permitted to lead evidence by affidavit, probably not to embarrass in the open court the public servant. That may be the object behind this act here. So the affidavits are accepted. Please note that here. This is an exception, 295 to the general rule. Then 296 में आ जाइए. Evidence of a formal character is an affidavit. The evidence of any person whose evidence is of a formal character may be given by affidavit and may, so subject to all exception, be related in evidence in inquiry, trial, or other proceeding under this act here. So what is a formal character? The court will decide here whether the evidence which is sought to be led is a substantive piece of evidence, a general type of evidence, whether it is in the nature of a corroborative piece of evidence, whether in the nature of a circumstantial evidence, direct evidence, primary evidence. The court will decide how important the formal character means. Actually, I would say that here the medical officer has put his signature. Yes, I have seen the injury report. According to me, this has caused according to me. It's a formal character. Then an autopsy report, admittedly the death has taken place. Death has taken place, how it is caused is not disputed. A has killed B is not disputed. When there is no dispute, if he admits in a confession, then there is no need to examine the coroner of Bombay or a coroner, a person who gave his certificate, isn't it? Certificate can be of formal character. A chemical analyzer will give a report here. This particular weapon is the result of this one, or a fingerprint specialist will say that here these are the these are the prints of the accused person. Or if the accused admits his voice having taken the bribe in the conversation, and the evidence of the person who recorded the evidence in a tape record is of a formal character. So this court will decide it, provided there is a confession, provided the accused or a dispute are ad idem, because these are applicable. I pointed out to you yesterday the provisions of section 56, 57, 58, where admitted evidence need not be proved, where evidence of a formal character not to be proved, where the court will take a judicial notice of certain record, isn't it? A court will not, suppose you are relying upon a judgment of the Supreme Court of India, you are not going to insist they examine the Supreme Court of India has given a judgment. You will take a judicial notice. The parliament has passed certain legislation. You are not going to examine parliamentarians, isn't it? So the court will take a judicial notice. This is properly done. The act is done. And the seal of the government of India. The passport is sought to be examined in a court of law. You are not going to summon the President of India, who is the owner of the, who's in whose name the passport is issued. Yeah. At the most, you may summon the passport officer in case of irregularity of fraud. And normally, an affidavit will do that here. This passport has been issued from our office. So these are all examples of the formal character of evidence affidavit which can be proved. Now, under section 295, I gave you when a magistrate or a civil judge, junior division, whoever has abused you, you want to take action. There is no bar. You can file affidavit by way of affidavits after complying with the provisions in CrPC.
Sir,
Yes.
sir, I have seen that sometime what happened, the Bombay High Court asked, chief engineer of the BMC to file a affidavit. They are not accepting the oral argument.
Mm.
So in the way of when the Bombay High Court asking the affidavit in as a statement, so it's fall under the proof means evidence, or it is
Yeah,
exception.
this question you asked me is because the Bombay High Court or Supreme Court will tell you don't make submission in the year, file affidavit. Why affidavits are filed? That you are accountable. In case the affidavit is wrong, you can be taken for action in perjury under section 293 of the Indian Penal Code. समझे ना? Affidavit is a solemn document which you made before the court of law under if the contents are wrong. That is why under the Code of Civil Procedure now, section 26 tells you that along with the plaint, you are required to file an affidavit. In the High Court rules, along with
Okay.
the writ petition, you are required to file an affidavit. Why? Because if the contents are wrong, you can be hauled up for contempt. Under the Contempt of Court Act, contempt is normally initiated when you have taken halafnama, when you have taken an oath that what has been stated in the affidavit is true to my knowledge and belief. I say and accept the submission, legal submission, which are in information, and I hereby say. That is, you are accountable. So if the affidavit is wrong, which after taking oath in the under the Oaths Act, then provisions of section 293 are attracted. Section 193, I'm sorry, section 193, check karo IPC. Whoever intentionally gives false evidence. So affidavit is regarded under the Evidence Act or is a formal character, maybe under the Oaths Act, maybe also under the provisions of the limited purpose of under the CrPC here when you give formal affidavit. Under the Contempt of Court Act too. समझे ना आप?
Sir, once it becomes once he submit before the High Court, so
Hmm.
after that it's become a evidence
Yes,
that
because
affidavit becomes evidence.
evidence become affidavit for the
So,
purpose of Contempt of Court Act, for the purpose of
okay.
initiating contempt action against you. Huh?
Okay.
Because
Okay.
under Article 215 of the Constitution of India, the High Court is a court of record which can take contempt by itself. समझे ना आप? You should know
Okay,
the
sir.
provisions of Contempt of Court Act, Section 2 and 3 and Section 14 and 15 of the Contempt of Court Act. So these are the special provisions relating to contempt when your affidavit is proved wrong. Even a civil court will take action against you. I will come to you that. Suppose in the Bombay High Court, in the original site, or in the city civil court, or in the small causes court, or maybe in the trial court, you made a false statement. Your affidavit is totally wrong. Your age is wrong. You took up the plea that to claim a false legal right on a document, you produce a bogus document and affidavit. Then the procedure is that the same court, the Bombay High Court, City Civil Court, Small Causes Court, Cooperative Court, or Revenue Authority, before whom you file the affidavit, before whom you file the proceeding, that court itself can take action. They will that
They
will
will
become
take the suo moto.
suo moto.
Suo
That is
moto.
section 340 खोलो CrPC. आपका भी बताता हूँ आपको मैं. Offences affecting the administration of justice is the chapter that I will deal with after the evidence part. That chapter, the provisions of as to offences affecting the administration of justice, section 340 से लेकर, that is chapter number 26. I will take it after some next time. Then 352. Okay. Immediately after evidence, I will take it. Don't worry. Because the बाद में
Okay.
thereafter judgment आएगा. So that is why you are called upon to file affidavit. So because affidavit has a evidentiary value for the limited purpose of taking action against the deponent. समझे ना आप?
Yes, sir.
Yes. 296 is clear now. Now what are the examples? Now 297 पे आ जाइए. Authorities before whom affidavit may be shown. Affidavits to be used for before any court under may be shown before number one, judge or a judicial or a executive magistrate. So they are the one who authenticate your affidavit. You make also notary pub. Number two, any commissioner of oath appointed under the High Court under the Court of Session. There is a Oaths Act. You go in the box, oaths के अंदर है. Then a notary appointed under the Notaries Act. There is a Notary Public Act of 1952. You know that, all of you know that here in every court of law outside the court, you need not go to notary will charge you a normal fees of maybe 100 rupees or 50 rupees. He'll put the stamp and give you. His notarization is accepted as evidence. उसके लिए भी आप evidence act खोल लीजिए. There is no need to rush to the court to examine him. Once it is done, notary public, there is a specific provision under the code, under the Evidence Act. Yeah, please open section 85 of the Evidence Act. When you are done, notarize a document, whether you are supposed to call the High Court judge, magistrate, or a notary to the public to the court. See, presumption as to power of attorneys. When a power of attorney is normally executed before the court shall presume that every document purported to be the power of attorney and to have been executed before and authenticated by the notary public or any court or a judge, magistrate, Indian council or a vice council, a representative of the central government is executed and authenticated. So the court is attaching significance to the notary public document or a signature of the council or a vice council or a judge or whoever has authenticated the document. Suppose you are in Mumbai, you have filed a suit, and your brothers and sisters are in America, Dubai, foreign country. They will not be able to come. You may be filing a suit for partition. In a suit for partition, all the parties must be joined together, isn't it? So they need not appear. You may tell them, you please execute the power of attorney. So if they are in America, then you go to the Indian Council. There's the embassy. Before the embassy, they will go and sign it, and is valid and take it. And in Dubai, India has a Everywhere there is a Indian embassy or a Indian council, consular general. These are the officers appointed by the central government. They are respected officers, and their signature is valid. They need not be examined as witnesses. Similarly, a notary need not be troubled unless you have taken a plea that other side fraud has been perpetrated. The person who signed, allegedly signed before the notary council, was a dead person. Such a person doesn't exist. Huh? And the notary is supposed to maintain a record of notaries and take his signatures. Even the Indian consular, they maintain a record. So they will send a certified copy, or in the notary is available, and relying upon the provisions of the Evidence Act, summons can be issued. Otherwise, generally the court shall presume, because you learn under Section 4 of the Evidence Act what is may presume, shall presume, and a conclusive proof. So, shall presume has a more stronger evidentiary value. Uh, Unless an evidence in rebuttal is sought for, a court will accept the report of an officer. So, similarly, an affidavit shown by under Section 297, mentioned by the officers in 291A and B and C, are accepted. They will not be called as witnesses to the court of law unless situation so warrants. सब क्लॉज 2 में आ जाइए 297. Affidavit shall be confined to and shall state separately such acts and deponents are liable to prove from his own knowledge and such fact as he has reasonable ground to believe to be true, and later so the opponent shall categorically state the grounds of itself. So you normally mention in the plain under order 7, which you prepare under read with section 26 of the Code of Civil Procedure. I, so and so, the plaintiff abonim, do hereby state on solemn affirmation and declare that what has been stated above in paragraph number 1 to 10 are true to my own knowledge, and what is mentioned in paragraph number 11, 12, 13 relating to jurisdiction limitation and relief sought is based on the information given to me by my lawyer, and I believe the information to be true and correct. So this is your affirmation. This is your affidavit. Abhi, in the CrPC, normally when you file a criminal complaint, there is no affidavit there actually. But when you file a verification statement under section 200, it is in the nature of affidavit. The verification, you file it under section 200, where the magistrate, judicial magistrate examines you as a witness or as a deponent. There you give the affidavit. I, so and so, do hereby take oath that what is mentioned above is true to my knowledge and belief. अगर वो गलत रहेगा तो they can be action against you for offences affecting the administration of justice. That chapter I will take you after completion of the evidence today, and evidence under the Code of Civil Procedure. Now come. Para 2 हो गया. Number 3, the court may order any scandalous and irrelevant matter in the affidavit to be struck out or amended. So, under the provisions of CPC में भी पढ़े हैं हमने, order 6 के अंदर, pleadings should not be scandalous, irrelevant पढ़े ना आपने, isn't it? The court has power to strike down irrelevant, scandalous pleadings. So, similarly, if your affidavit is bad, you cannot be abusing anybody. If you abuse anybody, if you are insulting language use kiye, the court will strike down the affidavit. The analogous provision in the CPC, you may see order 6 खोल लीजिए, मैं बता देता हूँ आपको, where the court can strike down such affidavit is order 6. Order 6 open कर लें. Verification of pleading, see that here again, order 6 rule 15 speaks of verification of pleading. Mean both the plain and written statement, you must have the verification clause. If you do not have the verification clause, the court will strike it down. Where is a scandalous material in the pleadings that is there? Can anybody point out to me from order 6?
Sir, it's 16, rule 16A.
Order 6, rule 16. Yes. Yeah. Order 6, rule 16 पे आ जाइए इधर. Yeah. CPC. Yes, in 15 to verification देखा आपने? Yes, just before amendment. The court may at any stage of the proceeding order to strike out, amend the matter of any pleading. Plain and written statement, your language must be decent and you know should not be scandalous, tend to prejudice, embarrass anybody, otherwise. So, Order 6, Rule 16 is analogous to the provisions of CrPC Section 397, Subclause 3. The court may strike it down. See, there are procedural laws, there are more or less the similarity here. And if you read it systematically, इसके बाजू में लिख लीजिए अब order 16, Rule 16 CPC के अंदर Section 297, Subclause 3 in CrPC. Okay. Then previous conviction or acquittal, how proved? So under the Evidence Act here, you have a right to accused person has a right to both prosecution and has a lead to read evidence on the previous conviction of the accused person. That character के बारे में पढ़िए आप Section 51 पे आ जाइए Evidence Act. Yeah. Section 52. Yeah. In 53 में in criminal cases previous or good character is relevant. 53A, evidence of a character of previous sexual experience not relevant in certain cases, or ladies के बारे में. Then 54, previous bad character not relevant except in reply. So what is relevant for the purpose of CrPC? Section 53 and 54. Both the accused may take up the plea that I am a person of a good character. If he takes up that plea, then evidence can be allowed. Then prosecution may prove that here previous bad character, he's a previously convicted, he's a habitual offender. So in that event, see Section 298 check karo. Previous conviction, acquittal, how proved? In any inquiry or trial or the proceeding under this court, a previous conviction, acquittal may be proved in addition to another mode by any law for the time being in force. 1. By an extract certified under the hands of the officer having the custody of the record of the court in which such conviction or acquittal was held to be a copy of the sentence. A certified copy is sufficient. You need not call the magistrate or a judge or a previous witnesses, please come and depose. Obtain a certified copy. It's a public document under Section 74 of the Evidence Act. Okay. Then clause B check kar le. In case of a conviction either by certified signed by the officer in charge of a jail in which the punishment or a partial thereof was undergone, or protection of a warrant of a commitment under which the punishment was suffered, together with in which such cases evidence as to identity of the accused person with the person so convicted or acquitted. So this is 298 mein, this is what you have to bear in mind. Certified copy of the judgment and record of the previous case. Certified copy from the jailer. Certified copy of the evidence, identity of the accused, where the identification parade was held, where the magistrate has given a finding under the identification of prisoners parade act में पढ़े हमने section 9 के अंदर evidence act में such evidence is laid here. So when you obtain the certified copies, coupled with the provisions of section 33 of the Evidence Act, that is the previous conviction, previous evidence recorded, certified copy I got. कल पढ़े हमने how the evidence recorded in the previous proceeding can be used in subsequent proceeding. To obtain a certified copy, so when you are a young trial lawyer, this is what you have to make preparation, because the moment you come to know that your client has disclosed to you, you have made inquiry, police ने disclose किया, these are all the previous conviction, please charges. Please apply for certified copies and keep. Thereafter, papers may disappear. The court may, the papers they don't keep for more than particular years, maybe 10 years, 30 years, 25 years. Sometimes the papers are disappeared. So the no sooner when you enter the court of law, so either you are a prosecution lawyer or for defense, then you make a certified copy and keep it. In civil cases also, you make searches very correctly and keep certified copies ready. And don't wait. Suppose you're applying for a probate of your grandfather in the High Court. Suppose the probate is lying with the registrar and you are required to issue summons and keep ready, and the original be summoned. Proti notary will issue summons to you. वो निकाल के रख लीजिए आप, otherwise the document will be lost. वो सब निकाल के तैयारी beginning से करना पड़ेगा आपको. These all provisions. Then come 299 में record of evidence in the absence of the accused. So section 272 mandated that here. Earlier we read it here. Evidence must be recorded in the presence of the accused. That is section 273. Now, what are the cases in which evidence can be recorded in the without the accused record of evidence? It is proved that an accused person has absconded. When he is not available for service. When a person is absconding, CrPC में provision है how the summons are to be effected upon the accused person in such a manner that you should know that here section 80 onwards के अंदर section 82 पढ़ो आप, proclamation and attachment. When a person is absconding, the court will issue proclamation against Dawood Ibrahim and gang, and our courts have issued proclamation because he is in Dubai or in Pakistan, whichever country he is hiding, so they are not available. Or attachment of the property under section 83. Now the property of several accused you have seen in the newspaper, properties have been attached and sold of the accused person. Section 82, 83. So these provisions are there in the Code of Civil Procedure, Order 5. Order 5 के अंदर substituted service होता है, isn't it? So CrPC के अंदर the properties will be attached, there will be proclamation. Please note that section 82, 83 will be then 84, 85, 86. These are all provision relating to when the accused is absconding, not obeying or respecting the summons or warrant of the gate. So in this such a scenario, when accused is not available, does it mean that the proceeding should not go against him? Certainly not. Proceeding should go on. Only service should be completed. Number one, if it is proved that an accused person has absconded and there is no immediate prospect of arresting him, because he is in a foreign country, we do not have a extradition treaty, isn't it? There are many accused persons have gone abroad, easy escape, and they do not want to face the trial. Court competent to try or commit for trial such person for the offence complained of may, in his absence, examine the witnesses, if any, produce on behalf of the prosecution, and record their deposition, and such deposition may, on the arrest of such person, be given in evidence against him on inquiry into and for offences with which he is charged, if the deponent is dead, capable of giving evidence, or cannot be found, or absence cannot be procured without the amount of delay. So the language of section 33 of the Evidence Act is used here. Please note that here. Expenses in connection in or inconvenience with the circumstance of the case would be unreasonable. So 299 empowers the court to proceed and record evidence in the absence of the accused when the accused is absconding, when the accused is not available, isn't it? For whatever reason maybe, after complying the requirement in that behalf. Then subclause 2 check kar lo aap. If it appears that the offence punishable with death, imprisonment or life has been committed by some or person unknown, the High Court or discretion judge may direct that the magistrate of the first class shall hold inquiry and examine any witnesses who can give evidence concerning the offences, and deposition to take may be given in evidence against any person who is subsequently accused of the offence, if the deponent is dead or incapable of giving evidence on beyond the limit of jurisdiction. So the power of the High Court, here of the High Court and the Court of Sessions, to appoint and hold an inquiry under the CrPC. They delegate the matter to the judicial magistrate first class, judicial magistrate second class, that certain persons are absconding, certain persons are dead, there are connected witnesses, they are unable to come before the court of law, you please examine them. This has happened in bomb blast cases. Several of the accused persons had not appeared before the court. You know that here, when you read the judgment of Ajmal Kasab's case, running into more than 700 pages, you will come to know one particular case. When I am teaching Evidence Act, I will take up Ajmal Kasab's case, that you will come to know, they'll come to know how the court has examined several witnesses. The entire full-fledged trial is before the court of law. So in what manner? So the courts are not powerless. The court has for 299 dispenses with the requirement of recording evidence in the presence of the accused, because the accused is not available. He has chosen to remain absent, run away, free from justice. So the show must go on. The court must proceed with recording evidence and do complete justice in the matter, and see to it that the person responsible for the commission of the offence are met with justice. Okay, these are the provisions relating to general provision. Now, there are other provisions here. Section 300 में पढ़ चुके हैं हमने. I do not want to read again. 300 generally deals with the proposition that here, once you are convicted or once you have been acquitted, there cannot be retrial. This section I read out to you. This is analogous to Article 20 subclause 3, isn't it? Doctrine of a double jeopardy under Section 11 of the Code of Civil Procedure, res judicata. Padhe na apne? So I won't be reading this again because we are not going to base. This I explained to you. Read these provisions of Section 300, and in case you have a doubt, again I will read it later on. Please come to Section 301. Appearance by public prosecutors. So when recording, the public prosecutor, assistant prosecutor as may appear and plead without any written authority before the court, in which case they on the trial or appeal. In any such case, private person instructed to pleader to prosecute any person in any court, or public prosecutor in charge of a case shall conduct the prosecution, and a pleader so instructed shall act under the instruction of a public prosecutor, assistant public prosecutor, with the permission of the court. Written argument of evidence is closed. Now, see, very interesting provision. Now, public prosecutors are appointed under section, when you see that the provisions of section 24, खोलेंगे आप, please open section 24 of the CrPC. The public prosecutors are appointed. Section 24. Yeah, these are all section 25, 25A. These are all public prosecutor, assistant public prosecutor. They are government officers. They are the central government, or state government appoints the people here. They are not required to file wakalatnama. Their mere appointment identification card is enough here. A private lawyer is required to file appearance and wakalatnama. Sometime what happened? 301 may they have a free license to appear and argue the case provided they have been assigned. 3012 says that it is the duty of the state to prosecute the offence on behalf of the prosecution. Now, sometimes there are many citizens, they want to have their own private lawyer. Such situation come before the court, my lord, I want to also have my private lawyer. The court will not decline. Okay, let your private lawyer also participate. He can be a watching advocate. Kya bolte isko? A watching advocate, but he will have to assist the public prosecutor. Public prosecutor will lead the main argument. You have a right to participate. You can watch, your lawyer can participate, a private lawyer, watch it. But he will have to instruct the public prosecutor, and you have a right to file your written submission in the court of law. Written arguments file kijiye aap. If you feel that public prosecutor is not doing a good job for some reason, and the court is allowing you to place it on record by filing your written argument in the matter, which is also permissible under the Code of Civil Procedure, written arguments can be filed. Under Order 18 check करेंगे आप, parties will be there. So written arguments are filed here under 3012 के अंदर. Then 302 देखिए, permission to conduct permission. Any magistrate inquiring into trying the case may permit the prosecution to be conducted by any person other than the public officer below the rank of inspector, but not person other than the advocate general or a public prosecutor, assistant public order, shall be entitled to do so without the permission. So who are the person qualified, who have the eligibility to appear before the court to conduct the prosecution? The names are given here. Uh, the public prosecutor, advocate general, even inspector, provided he has the qualification in the eyes of the magistrate. Then assistant public entitled to prosecute. Provided that no police officer shall be permitted to conduct the prosecution if he has taken part in the investigation of the offence with respect to which the accused is being prosecuted. So the IO, the investigation officer who has conducted the investigation, he cannot say that I will fight the case. Huh? Like in the civil court proceeding, an advocate who has drafted the plaint and arguing the matter, he cannot be a witness. Please note that you cannot be a witness and the law counsel for the plaintiff or defendant. You have to keep away. You have to keep distance. You are not permitted. The ethics do not demand that here. So similarly, a public the officer, the investigation officer who conducted the proceeding, because otherwise under 302 the court may, the police officer not below the rank of inspector is entitled to appear and argue the case with the permission of the court when the public prosecutor is not available. Or in many of the courts, you know that the stage of the remand under section 167(2), when the accused is brought before the court of law pursuant to arrest under section 57 CrPC and article 22 of the Constitution of India, the police officer goes in the box, he salutes the magistrate and he presents the case. In fact, the assistant public prosecutor is sitting and he will give, because the police the police officer who conducted the investigation, he will show the case diary under 172 CrPC to the magistrate. The case diary, the accused or his lawyer are not allowed to see at this stage. Unless in the stage of the evidence, he is using it for refreshing his memory, he can cross-examine. At the stage of 167(2) for obtaining a bail or obtaining a police custody or jail custody, you are not permitted. The court only sees. The court will peruse the first information report. The court will peruse the diary. The court will determine whether I should grant custody to the police for further investigation, as investigation is not completed within 24 hours as per the mandate of section 57 CrPC, or should I remand him to the judicial custody? You know that here, when investigation not completed, the magistrate or a session judge normally give the custody to the police officer first initially for 2 days, 3 days, maximum 15 days. Then there's a limit under the CRP, 60 days and 90 days, depending upon what the nature of the crime. If the offence is punishable below 7 years, within 60 days, investigation must be completed. उसके बाद तुमको रिमांड नहीं मिलेगा. If the offence is punishable for more than 7 years, then you must complete the investigation within 90 days. Otherwise, the accused will be entitled to statutory bail, isn't it? He will be out. Magistrate has no right to keep him. And you must be alert as a young lawyer at that time. My lord, if you don't press the application for bail and next day you allowed, thereafter next day बढ़ेंगे आपको bail नहीं मिलेगा. Please note that. It's very important. No, you must know the dates. अगर डेट स्किप करेंगे आप, the next day, of course, there is no, the CrPC doesn't lay down the time limit for filing charge sheet. The police officer will take up the plea, the accuser abroad. It's a very deep the conspiracy. I had to unearth, and witnesses are not available. It may take time. So advisedly, the legislature or parliament has not fixed the time for the police officer to complete the investigation. But doesn't mean that you can continue to incarcerate the accused person and violate his fundamental right of life and liberty under Article 21. That is why Section 1, the law mandate in CrPC, in case the charge sheet is not filed within 60 days and 90 days, they are entitled to statutory bail. Isn't it? 167(2) की language पढ़ लिया हमने. I think I read it out to you. So, the officer who conducted the prosecution cannot say that here I would like to conduct. Similarly, an advocate who is conducting the case cannot be a witness. In case you are likely to be a witness, you must resign from the case. Please note that in any case, in either criminal prosecution or a civil case, you are likely to be a witness. There are lots of judgment of the Privy Council and Supreme Court in that regard. Old judgments you can see, we can cite it when Evidence Act is cited here. So you cannot be a witness and a pleader both. So advisedly, CrPC is beautifully drafted in this regard. The subsection 2 of 302 clearly keeps the officer, because you will be interested person. You will be naturally, once you conduct the case, you become personal. You are a overzealous officer. You have conducted the prosecution, and you will say, I will teach him a lesson. Isko andar hi dalo. You will not be an impartial officer. समझे ना अब? In such a scenario, you are out. Number 3. Yeah, number 303 पे आ जाइए. Right of a person against whom proceedings are instituted to be defended. Any person accused of the offense. So 301, 302 deals with prosecutions, right? Who can lead the prosecution? 303, defense. Any person accused of the offense before the criminal court or against whom proceedings are instituted under this code may have right to defend by any pleader of his choice. So this is the mandate of Article 22 of the Constitution of India, 21, as well as the directive principles of state policy under Article 39. You are entitled to lawyer of your choice. 57 के अंदर भी couch किया गया है. So these are the salient, the fundamental rights under the Constitution, which are available to all citizens here. He can have a lawyer of his choice. You cannot tell that you take A, B, C, D lawyer in this matter. Okay, then. Yes. Then 304 में देखिए, legal aid to the accused of the state in the expenses. So free legal aid must be provided, isn't it? Isn't it free? आपने free legal aid का provision check करें Constitution of India के अंदर Article 39 A and B of the Constitution check करो. If I am not mistaken, Article 39B है ना ये? Yeah, free legal aid Article 39 ये check करो. The state shall secure that the operation of a legal system promote justice on the basis of equal opportunity and shall provide a free legal aid and suitable legislation scheme in any other way to ensure the opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. So Article 39A was enacted in the Constitution of India. It is the 42nd amendment in the year 1977. All of you should know, remember this. This Article 39A is analogous to Article 304. 304 was subsequently added, possibly after the judgment of the Supreme Court in Husainara Banu's case, where the blinding in Bihar took place of various persons, that you know that. And that is how we have several legal aid committees under the provisions of Section 79 CPC में पढ़े 89 के अंदर, the state to provide free legal aid committee, mediation, that all respect. Okay. Then the High Court may, with the previous approval of the state government rule, provide for selecting pleaders. See, a free legal aid के provision है. No one should be convicted in any court of law without being provided an advocate of his choice, isn't it? It is mandatory. Even the accused, the magistrate must tell the accused person, do you want a lawyer? Do you want a lawyer if you, in case you do
Sir,
not? Yes.
Sir, free legal aid service is for those people, those who are especially financially
Yes.
backward or under the 303. If the person is rich and he wants a free legal aid,
Yeah.
so the court permit or court can deny it because he is not under the weaker section.
But under Article 39A, you are entitled to, that you cannot deny it. And when you see the provisions of the Constitution of India, that is the, of course, rich people will not come to the court of law, you give me free legal aid. Only poor people will come to the court of
Okay.
law. So in that event, you cannot be denied that opportunity of being given. Promote free legal aid to suitable legislation scheme to ensure opportunities of securing justice denied to citizens by reason of income. Naturally, when you are a have not, when you are a person of disability, when you are an underprivileged person, only can approach the legal aid committee. Why
Because
will
they ask for a
you can
legal.
You cannot
financial certificate.
you cannot expect Mukesh Ambani to approach legal aid committee, isn't it?
Yes, sir. But sir, sometime what happened? The legal
Yes,
aid service committee, they
yes,
ask for
yes.
the economical
It
certificate
I
from the all
yes,
custom house.
yes, yes. That means the person should not be denied on the basis of his economic condition. That is the reason behind. He should be represented. Naturally, a person who is well-to-do will engage a lawyer. If he doesn't want to engage, it is his wish. The judge will ask him, even under the provisions of, see that here, where is the provision? Even the magistrate will ask you whether you want a lawyer or not. Here, Husaina Rabano's judgment is there in that regard. Article 22 of the Constitution, check karo aap uske andar. What is this? Say that here. Article 22 check करें. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within 24 hours, excluding so and so maintained. Nothing shall apply to any person for the time being in force. Any person arrested detained under the law for the time being in force prevention. No law providing for prevention shall be authorized detention. 21 advisory board consisting of a high court so and so. Then देखो फ्री लीगल एड भी है यहाँ पे. Law for the time being in goes, any person detained in law for the time being in goes. Yes. So there are a lot of judgment on this point. You check it up here. So one judgment which I am giving you, Husainara Banu's case. Husainara Khatun. Just Kumar, just type in the Google में Husainara Khatun's case. Please read and come Husainara Khatun's case. I will give you.
Sir, it's under Article 22 or 21?
21 में आ गया. You just type in
21.
you तुम पढ़िए हुसैनारा खातून
Okay.
करो. हुसैनारा खातून's case is well known. It is the judgment of Justice Bhagwati. 1978 Supreme Court है, 79 80 में judgment है. Justice Krishna ये judgment है ना, बिहार से गया है. 79 Supreme Court. Husainara, Hussainara, Husainara Khatun. This judgment will discuss in the next date of occasion. Just remember it. I will discuss it with you. I am fully aware of the judgment. Okay. Yeah, 304 के बाद आ जाइए आप. Then you also have the provisions of free legal aid committees. Section 89 के अंदर CPC के अंदर yeah. Then you also have the provisions like Lok Adalats, isn't it? लोक अदालत भी हैं आपके पास. लोक अदालत के अंदर लीगल सर्विसेज अथॉरिटी एक्ट ऑफ 1987. दिस वाज स्टार्टेड बाय जस्टिस कृष्णा अय्यर एंड जस्टिस भगवती. ये सब पढ़िए आप. लोक अदालत देख लेंगे ना आप. लोक अदालत में भी दे विल डील विद द केसेस. So every civil code and criminal code, they decide that formal nominal fees is there for those people who are willing to pay, and those who cannot pay can be exempted. Please note that Lok Adalat mein bhi aa jaiye. That is a Legal Services Authority Act of 1987. This will be applicable to both CPC and CrPC criminal cases. That you will find it also in section 89 of the Code of Civil Procedure. Okay. Then what is the time now? Yeah, another 10 minutes we can deal with it now. Now 305 mein aa jaiye. That is when corporation and societies are accused. Now, what are the provisions? What are the provisions of a society is a legal entity, but where the management is brought on record. In the case of companies, company is a legal entity, and one of the responsible director who is because every director cannot be prosecuted. A person who is in the management and control can be executed. Similarly, under the Societies Act, if the secretary is responsible for the act, you cannot implicate the chairman and the office bearers, other office bearer, treasurer in the matter. So these are the person who are responsible. Then 306 speaks of a tender of a pardon to accomplice, where more than 2, 3, 4 accused, one person is willing to cooperate with the court and the police officer that that is a Kasab's case. Huh? Isn't it? Kasab का case में पढ़ेंगे आप इसके अंदर. He was given pardon and accomplice because he said that I will not support Pakistan. I will give evidence. He gave evidence against all his accused person. He was given pardon. Ultimately, he retracted, वो अलग बात है. An application was made by his lawyer, but the court rejected the retracted application. So 306. Now presently now the Sheena murder case में the driver, her driver, the lady driver, is a accomplice and he was given pardon under 306. So when he gives a pardon, then he becomes the prosecution witness. Then how is he examined? Power to direct tender of pardon 307. देख लीजिए आप 307 के अंदर trial a person not complying with the condition. Suppose if he is not supporting prosecution, not helping the court in giving evidence, which on the basis of which he was, because the moment he gives, he was given pardon, he was tender a pardon as an accomplice, he has to support the police. He cannot support the defense. The moment if he doesn't support, he will be again renumbered as accused under 308 and the proceeding will go against him in the matter. Okay. Then power to postpone, adjourn the proceeding 309. In every inquiry, a trial proceeding shall be continued from day to day until the witness attendant has been examined, finds that the adjournment of the same beyond. So a criminal trial, when it commences, it should go on from day to day. Please note that here. 309, the court has to record heavy reasons why it is postponing. Provided the inquiry trial or offences under these all rape cases 376, the offences so and so shall be completed within a period of 2 months from the date of filing of the charge sheet. Very difficult, onerous task upon the judges, especially a session judge, a special judge in a POSCO court. 2 months के अंदर complete करो. Under the POSCO Act, the time limit given is 1 year. CrPC is giving you within 2 months time from the date of the filing of the charge sheet. There the filing from the date of the filing of the taking cognizance is 1 year under the POSCO Act. When you see the POSCO Act, वो अलग बात है. Then court after taking cognizance of offence commencing the trial, advisable postpone, and under what circumstances postponement can be granted, the magistrate or a judge or a special judge has to record a very cogent reasons why the trial cannot take place. Like similarly under the provisions of Order 17 of the Code of Civil Procedure, no adjournment can be granted. These provisions of section 309 or akin to Order 17 of the Code of Civil Procedure. आप चेक करें, Order 17 भी चेक कर लें जरा 2 मिनट में. Yeah. Attendance of witnesses. Attendance of Order 16 here, argument. Order 17 किधर गया? Adjournment. Court may grant from time to time hearing. Court will award cost under sub rule 2. The proceedings will go on from day to day hearing. The hearing shall be continued from the day to day until witness is attended. See this here? Order 17 पूरा पढ़ लीजिए आप. बॉम्बे का अमेंडमेंट भी है. Cost, heavy cost will be awarded any advocate or any party demanding adjournment. Provisions of section 313 CrPC are akin to Order 17 of the Code of Civil Procedure. Okay. Then ये सब recording होने के बाद oral arguments and memorandum of argument. So under the provisions of Order section 314, any party to proceeding as the case may be after closing of the evidence. So before the closing, I want to give a 314, I will take it last May. Accused a person to be competent witness. So under 315, the accused person, 315 comes into play under after 313, where power to examine the accused. Please note that 313 के हिसाब से उसे आई एम सो सॉरी या वी आर कमिंग सॉरी कम टू 309 के बाद आई एम कमिंग 309 के बाद 310 local inspection. The magistrate may at any stage of local inquiry proceeding give notice to parties to visit, inspect the place so and so committed or so and so. So local inspection by the magistrate to understand the nature of the offence, place of occasion. uh, the provision for local inspection in the Code of Civil Procedure is Order 18, Rule 18, where a civil judge may visit the suit premises and the place of evidence. इसके बाजू में लिख लीजिए आप Order 18, Rule 18. I won't. Last time I read it to you. Today I won't read it again. Then power to summon material witnesses, examine person. Court may at any stage of inquiry. See, one of the question asked me by the student, how many witnesses you can examine. Court may at any stage of inquiry, trial, other proceeding under this court, summon any person, examine any person in attendance though not summoned as a witness, recall and re-examine any person already examined in the court, summon, examine. So there's a wide power to examine witnesses. This power is equal under the CPC under Order 18, Rule 17, also 151 के अंदर. When you check the provisions of Order 18, Rule 17, such a provision exists here under the Code of Civil Procedure. Uh, power to inspection 18 again, 17 check here, 16 power to examine witness, Order 18, Rule 60, 17. Court may recall, examine any witnesses. Order 18. Now CPC के अंदर additional advantage for a civil judge is that if the act is silent on examination of witness, section 151 inherent power can be used. But whereas a magistrate and a session judge cannot use inherent powers under 482, only High Court can apply for that. So that is why the provisions of section 311 are much more wider than order 18, Rule 17. Order 1817 says, yeah, the 311 is very powerful. A magistrate can call anybody, examine anybody, re-examine anybody. So full, what do you call it, latitude is given to the magistrate or a special judge, session judge, to examine any number of witnesses at any stage here. Even after the closure of the evidence, even just before the judgment is sought to be passed. Just before the judgment, one day matter is kept for judgment, my lord, I want to examine a material witness. You give reason why the court has power to do that. Very interesting provision. Then power of the magistrate to order person to give specimen signature 311A has been added after 2006. Please go through this. This section is akin to section 73 of the Evidence Act. I will read this section for you. If a magistrate of the first class is satisfied that for the purpose of any investigation or proceeding under this court, it is expedient to direct a person, including accused person, to give specimen signature, handwriting, he may make the order to make that effect. In that case, the person to whom the order relate shall be produced, shall attend at the time and place specimen, such order shall give a specimen. Provided that no order shall be made under the person has at some time been arrested in connection with such investigation or procedure. So 368, 367 CrIPC may be an offense. That is a fabrication, isn't it? आपकी जाली सिग्नेचर करके इसने नोट निकाला उसके अंदर, which are offenses. So when pursuant to FIR the accused is arrested, and you may say that you complainant will say that the accused person is my employee, my accountant. I ask him to gave him a check to withdraw check of sum of rupees 1 lakh. He has withdrawn 10 lakh by forging my signature. Forgery कैसे किया? Exactly duplicate किया, isn't it? So when he is arrested under by the police officer, when trial commences, the magistrate has power to ask the accused, you sign before me. he will compare the check, he will compare the वकालतनामा. सेक्शन 311A के अंदर कंपैरिजन अलाउड है. सेक्शन 73 खोलो एविडेंस एक्ट. दिस इज इक्वल टू एविडेंस एक्ट 73 में एग्जिस्टिंग प्रोविजन है. CrPC is trying to make it more clean and clear. सेक्शन 73 खोल लीजिए. 73 के अंदर CPC के अंदर ऐसा प्रोविजन नहीं है, बट 151 कैन बी इन्वोक and section 73 of the evidence act can be comparison of the signature. 73 of the evidence act, comparison of the signature, writing, seal with other admitted or proved in order to ascertain whether a signature, a writing or a seal is of that of a person or by whom a purported to have been written or made. Any signature, writing or seal admitted, proved or satisfying the court to have been person to whom purports to have been written or made. Any signature, writing or seal admitted, proved by the satisfaction of the court to have been written or made by the person may be compared with the one which is to be proved, although that signature, writing, seal has not been produced or produced. The court may direct the person in the court to write any words or figures of the purpose to enable the court to compare the words or figures so written figures so and so forth. This section applies also with necessary modification to finger impression, that is in the year 67. So Sir John Stephen, way back at the time when Evidence Act was drafted 1872, was intelligent enough to draft this from the English Evidence Act of Taylor. Taylor's Evidence Act check करेंगे आप. Those who are anxious to know about this provision, Taylor check कर लें आप. So thereafter, so the CrPC has probably emulated this example by inserting the provisions of section in the CRP 311A in the CrPC with effect from 2006, because lots of forgeries are taking place, lots of economic crimes are taking, banking crimes are taking place. So Evidence Act का procedure may be cumbersome. That is when the evidence commences. यहाँ पे immediately after arrest, the no sooner arrest is arrested, at the interlocutory stage when the accused is brought before the court, at the time when what you call it remand application is being heard, and that time the magistrate can tell him sign it here. Whereas 73 is a time, probably at the time recording of evidence will take place. That is why this legislature has been taking more precaution. That is why section 311A is added here, giving more powers to the magistrate in the matter. See, expenses, 212, expenses of complainant and witness. Subject to any rule made by the state government, criminal court may be taken order payment on the part of the government the reasonable expenses of any complainant witness attending the court for the purpose of inquiry, trial. So normally the court of law may, when issue witness someone to examine a witness, B witness, you have to pay some traveling expenses. They are called in Bombay batta charges. क्या बोलते हैं? batta charges कहते हैं इनको. And of course the person summoning, you are a plaintiff, you are a complainant, you want to examine XYZ, you are a handwriting expert, government, you pay the charges. Traveling a court may fix it up, and or mutually you agree and give. If he is to be flown from Bangalore and Calcutta, Madras, you have to pay his plane ticket and also staying charges. Please note that here. Then 313 to Parchukame, where after the prosecution closes the case, and before the accused is examined, before the accused examined under 315. 313, the accused is called upon to explain the circumstances appearing against him. Because under the scheme of the CrPC, when you open, for example, section 225 of the CrPC, where session trial take place. आप जरा खोल लीजिए. No sooner the evidence starts, under the provisions of see chapter number 17 के अंदर 230 starts with prosecution witness. After framing of a charge, charge होने के बाद please recorded under 229, plea recordment, गुनाह कबूल है नहीं कबूल है, prosecution will commence the evidence that the police prosecutor 230 के अंदर, following the provisions under section 273 onwards till 299. Then evidence prosecution 231, evidence होने के बाद under 232, if the session judge is not satisfied with the evidence recorded by the prosecution, बोलेंगे कोई दम नहीं है evidence के अंदर, the prosecution has not been able to prove the case, he will discharge, he will acquit the accused. He will not tell the accused, I want to examine you. He will not invoke the powers under 313. He will not even tell the accused, do you want to lead evidence? If the session judge satisfied, evidence बहुत ही कमजोर है, prosecution evidence नहीं लिया, he will acquit under 232. Then 233 will come into play when the accused is not discharged. I mean, the session judge prima facie is of the view that there is a lot of substance in the evidence of the prosecution. Police officer and prosecution has led good evidence against the accused. Then the judge, before proceeding further, will tell the accused, you file your evidence. He may accuse, he before evidence, he will put questions in written statement, file the answer. He is not acquitted, he shall call upon, he may enter the defense and adduce evidence, he may be so and so. 232 में adducing evidence come into play under 315. उससे पहले the magistrate or a judge, session judge has to call upon the accused under the provisions of 313, 313, please explain the circumstances against you, which is not an evidence, but it is his statements are recorded. In every trial in every inquiry or trial, for the purpose of enabling the accused personally to examine any circumstances appearing in the evidence against him, the court may at any stage, without previous warning, accused put the question. Now, this section has become mandatory as per Supreme Court judgment, many of them now. It is no more a procedural one. So, even before invoking the provision of 233 and section 315, the session judge has to put question to the accused person. Now, whatever questions I mentioned to you last time, they are not evidence. Agar jhoot bhi bolega, to he cannot be prosecuted for perjury. That is the effect of 313. It is only when the magistrate or a session judge is convinced that here there is no substance or substance, he will tell the accused, do you want to examine your witnesses? That is the provisions of 315 will be pressed into service. That is, you examine your witnesses. Then in a case of session case, section 233 will come into play. In a case of a warrant trial, on a police report, then the provisions of 243 will come into play. Please see that section 2 evidence for defense in a trial. Then in the cases in a cases otherwise than in a police report, in a warrant trial, the provisions of section 247 will come into evidence for defense. Remember these sections very well, very important. Very important sections. 233, section 240, section 239, sorry, section 243 and 247. These are warrant trial cases. Then in a summon case, we know that here I told you the charges need not be framed. Procedure when not convicted in section 254 के अंदर the magistrate will record evidence under 254 and he may acquit or non-acquit the matter. Then in a summary trial under section 262, the magistrate will record evidence without framing, of course, any charges. So these sections are with regard to a trial where recording of the witnesses, prosecution and defense in a trial before a court of session, in a trial before a magistrate in a warrant triable case, in a trial before a magistrate in a warrant triable case, otherwise than in a police report and a police report, then summons trial in a summons cases, that is section chapter 20, then a trial in a summary case, because there are 5 types of trials which you should know this. Then that general provision, these are the special provision, then the special provision will come into play, section 315. If the time is up, I will stop, I will take next lecture, I will complete next, that is on next volume. Okay, we'll stop it here. 315 onwards, for how the accused to examine witnesses, and I will also elaborate on the statement of the accused, whether he can be held for perjury, whether under the Evidence Act he is bound and liable to answer each and every question. If not answering, what action court can take, then what are the powers of the appellate court to record evidence, वो भी ले लेंगे आप CRPC के अंदर. And we'll try and complete one more lecture you give me for evidence. I will complete in the next lecture both CRPC evidence, and also I will point out to you next time how the evidence is recorded by a civil judges under the Code of Civil Procedure, invoking the relevant provisions of Evidence Act, which are common to both CPC and CRPC, barring the provisions such as character evidence and confession are not applicable to the provisions of, are not applicable to civil cases, which is based on preponderance of possibilities, and evidence under section 115 and 116 with regard to estoppel are basically related to civil proceedings, and they don't come in play in a criminal prosecution. Okay, I will wind up with this today. Tomorrow, remind me, day after tomorrow, we'll start with the evidence of the accused person. Accused is competent to be examined as a witness, 315, and power of the court to examine witness. Once the prosecution has closed the case, then the magistrate or a session judge is bound and liable to call upon the accused to please explain certain circumstances which are going against you. I'm afraid you have to explain this to me. This before, if the magistrate is happy with the explanation, he can discharge him. He will need not even ask him to step into the box. He will not even need to press into service for provisions of section 315 of the CRPC to asking him to lead the battery of his witnesses. That is the crux of this matter. There is more indulgence is given to the accused person. There is a lot of latitude is given to the accused person in CRPC in comparison to civil cases, where the pleaders and parties are at liberty to anybody want to examine. Section 118 of the Evidence Act tells that you may examine any number of witnesses, any person. There is no bar. The law doesn't tell you as to how. Only the magistrate and the judge, under passing an order under the provisions of section 135, they will tell you whom you should examine, who not examine. But when you see the provisions of 118, 119, 120, 20 से लेकर 27, 30, till 134, who are the person to be examined? Evidence Act में सीख लीजिए आप the provision chapter number 9, starting from section 118 से लेकर 134, how many number of witnesses who are the who can be competent witnesses? This is applicable to both CPC and CRPC. Please note that. Bear in mind the provisions of Evidence Act 118 to 134. Beside, last time you remember the provisions of section 137 for examination chief, cross-examination, re-examination, 135 for protection and order of witnesses, along with the order in the CPC and CRPC, the magistrate or a civil judge will regulate the procedure who should be examined. Then admissibility and non-admissibility of document evidence order is passed under 136 by the magistrate or a civil judge. Given you illustration, what question to be put, what questions and will. So remember these sections are very well. 137, 135, 136, 138, then 118 से लेकर 134. These are material. Cross examination में सिखाया मैंने आपको 145, 146 impeaching credibility, then 153 previous questions in the previous examination, impeachment under 150, but you can impeach the credibility of a witness, then a corroboration under section 156, then how to declare a witness hostile your own witness when not supporting you, section 154 of the Evidence Act. Then when you want to produce certain document which are not produced at the stage of a CPC, CRPC, section 162 of the Evidence Act, by calling upon the requesting the court to produce document, other side after giving a notice under 163. When they don't produce it, effect of a notice is up. समझ जाइए आप. We'll discuss it out. Anybody has any question in today's lecture, please ask me. We can wind up after the question hour session. Any questions? Looks like everybody has understood this. Huh? No doubts
Ye-
today?
yes, sir.
Okay, no problem. Then, if you understood, I'm very happy. Okay, next time,